Riley.
Yep.
Riley. Last time he was here, Your Honor, asked him to
Mr. Vaughn?
do some employment, which he's done. I've got proof of that.
Okay.
Schooling, I spoke to his mother and his aunt, and the issue there is, he doesn't like the school he's zoned to. It's not a great, fit for him. And so he's trying to get with the aunt, and there's just some logistical issues. But I spoke to both the individuals, and I mean, he's making good faith efforts to do it. He's just, has not yet.
Is he here?
Yeah, he's here.
Okay. Ridley, come up. Is mom here?
That,
Who's that?
I don't. Yeah. Sure. I spoke to her last night, and she wants to, he's here. And so I told her. Okay, yeah. No,
Is that mom?
yeah.
Hey, mom? Come on up.
Yes. So it's pretty
Thank you so much for coming. It's great. So what's going on with Mr. Ridley now?
I haven't had chance to live in school, like the holiday work schedule, but he's looking for a job, and I'm trying to get him make sure he else.
So you're not doing anything now? You stay at home and do nothing?
I was.
He's looking for a job.
I got put like 3-4 applications in.
School is more important, Mr. Ridley. You need to get your education, man. You need a high school diploma. At worst comes to worst, we can give you paperwork so you can do the schooling at home and get your GED online at a minimum, and we can give it to you for free. But I mean, you're at home you're not working, you're not going to school, you're doing nothing to make life better for yourself. Life doesn't get easier the older you get. It gets more difficult. If you don't have a job, if you don't have an education, you will end up nowhere in life.
Judge Fleischer isn't just laying down the law, he's delivering a reality check. You can feel he genuinely wants Ridley to succeed, but patience has limits. This is that critical crossroad moment. Will Ridley wake up or waste another chance?
Sucks without money. Trust me. Do you understand? Hey, do you mind giving him the paperwork, please? We need to be somewhere, Mr. Ridley. I'm going to give you another couple weeks, 2.5 weeks. At the minimum, be enrolled to start working on your GED. Do you understand? I'm also going to drug test you. I'm not going to let you there's no smoking weed, none of this. Do you understand? If I find that you're using, I'm going to revoke your bond. I'm going to keep you. Do you understand? All right.
One other issue, Judge, we would request, the complainant has made contact with the DA's office and let her thoughts be known on the case in a RIP call. And so we request that the no contact be just brought down to no threatening, harassing.
Who is it?
It's a girlfriend situation, Judge. And I spoke to DV about it. He reviewed it and said he was going to leave notes, that they had no opposition to that.
Well, yeah, or even something else.
And yes, that is correct. The RIP does say no contact, so no threatening, harassing would be fine.
Okay. I will amend your bond condition, Mr. Ridley, to have no lasting contact with the complaining witness in this case. You're not to be in possession of any weapons. Do you understand? You need to start working on your education. Life doesn't get easier. Do you understand?
Yes, sir.
That's my main concern. You graduate, you get your GED, we're all going to be jumping up and down because that's what you need. Without a high school diploma, you will literally make pennies when everybody else is making dollars. Do you understand? I'm bringing you back in 2 weeks. If you've done nothing, it's not going to go well. Do you understand?
Yes, sir.
Okay, see you in 2 weeks. All right. Good morning, Mr. Arling. Sir, you are charged with unlawful carrying of a weapon. You are facing up to a year in jail and or a $4,000 fine. You're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge.
Okay.
On January 16, 2025 at 12:04 a.m., the officer observed a vehicle traveling the wrong way at Belfort Avenue in Harris County, Texas. A traffic stop was initiated and the defendant, the driver, did not initially roll down his window. After multiple commands by the officers, the defendant finally rolled down his windows and the officer observed the defendant to make further movements as if to conceal something. The defendant did not produce his driver's license and the officer observed a strong odor of marijuana from the vehicle and his person. The officer observed the defendant to have a loaded firearm in his waistband, and the defendant stated he smoked earlier and was not the registered owner of the vehicle. The officer located in plain view, sticking out of the defendant's right pocket, a small package with training and experience is used to conceal marijuana. PC search was conducted and the officer found 3.31 grams of marijuana under the driver's seat, and the defendant admitted the marijuana was his.
So Arlene, I'm going to find that there's probable cause to go forward with your case. If you run his license, see if he has.
Not eligible, Your Honor.
Okay, you are not allowed to drive. I am making that a condition of your bond. I don't care what's going on in your life. If you
That's vintage Judge Fleischer, zero tolerance, full accountability. He's seen too many excuses in his courtroom. It's not about being mean, it's about drawing a line. What do you think, fair call or a bit too firm?
don't have a license and liability insurance, you are not allowed to drive. Do you understand? You will be signing a promise with me. But like I said, I don't care if there's a burning building and you have to save 50 people. If you don't have a license and insurance, do not drive. I'm going to have you come up here, swear to us that you're not going to drive. Do you have the ability to hire a lawyer, Mr. Arlene? Okay, I'm going to have you fill out an application. I need to know everything about you and I'll take a look to see whether you qualify. Don't pick up any new cases. Don't become a danger to my public, and above all else, do not drive. Do you understand? Okay, come on. Sir, you're charged with unlawful carrying of a weapon. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
One moment, Your Honor, it's loading. Okay. On January 15, 2025, the officer was conducting surveillance in the Greenpoint area, and the officer was in an unmarked vehicle in an apartment complex and observed 18-year-old defendant join up with two other males, co-defendants. He had already witnessed using a firearm. The three males walked around the apartment complex together, and the officer witnessed the defendant being given the firearm and wave it around. The two other males encouraged the defendant to shoot the gun, and the officer did not see the defendant fire the weapon, and the officer maintained visual until the officers were able to detain all three defendants at a nearby gas station. The gun was found in the co-defendant's waistband, and all three individuals were placed in custody.
Mr. Saavedra, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to be in possession of weapons. Do you understand? I'm also ordering you as a condition of your bond not to be in contact with any. Did anyone else get arrested in this case? Or is it
Zero.
just him? I'm ordering you not to consume alcohol or illegal drugs. I'm sending you for a test right now. You're to come back. If you fail the test, if you fail to come back, I'm going to issue a warrant for your arrest. Do you understand?
Your Honor, there's a co-defendant in court 4. The cause number is 2547734.
You want to send it? Yes. Okay, so let's just do this for now. Go ahead, take a seat for me. We're going to transfer your case to the other court because that's where it belongs. Okay, please. And you are charged with driving while intoxicated. It's elevated to a Class A misdemeanor because of the high blow. You are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, man.
Yes, Judge. On January 16th, 2025 at 2:02 a.m., the officer was dispatched in an attempt to locate. The officer was advised the defendant's sister was concerned for her well-being after not hearing from her. The defendant's sister stated her last known location was the Den, a bar, where she got a flat tire. While searching the area, the officer located the defendant's vehicle at the entrance of the University of Houston, and a witness was flagged down to assist changing the defendant's flat tire. The witness stated he observed the defendant as the sole occupant of the driver's seat of the vehicle, and the surveillance video showed the defendant's vehicle in motion at the time the witness came into contact with the defendant. The defendant was identified with Texas driver's license, and the officer made contact and observed a strong odor of an alcoholic beverage, red, glossy, bloodshot eyes, and slurred speech. The defendant admitted to drinking a wine cooler earlier in the day, and standard field sobriety tests were conducted. The officer observed the defendant to be unsteady on her feet as she walked to the sidewalk, HGN 6 out of 6. walk and turn 5 out of 8, one leg stand 1 out of 4. The DIC was read and the defendant consented to breath. The results were .185 and .181.
And you're telling me there's video of her driving?
Yes, Judge.
Ms. Levy, I'm going to find that there's probable cause to go forward with the case. Have you run your license and any prior DWIs?
Driver's license is eligible and no priors, Your Honor.
Okay. I am ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. You will be randomly tested. If you consume alcohol, illegal drugs, I'm going to revoke your bond, put you in jail. No more PR bonds. Do you understand, ma'am? Would you like to apply for a court-appointed lawyer? Okay, I'll give you an application. I'll take a look at your numbers, and if you qualify, we'll provide you a lawyer today. Okay, just everything's fine. Don't worry. Just be safe. Okay, just don't. Okay, I don't want to talk about the case. Let's have you fill out the application, then I'll have you talk to a lawyer today. Okay, ma'am? Please.
Right this way.
Sir, you're charged with evading arrest or detention. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On January 15, 2025, the officer was dispatched to Texas Southern regarding a male on campus possibly carrying a firearm. The caller provided the name and dispatch ran through arms and located a recent picture and a trespass notice. The officer observed the defendant walk into the library, immediately walked out accompanied by a second black male, and the officer attempted to detain the defendant, and the defendant ran northbound, ran through an apartment complex. The officer drove through the complex and set up a perimeter and observed the defendant run out of the complex. The officer exited a marked patrol vehicle in full uniform, drew a duty weapon, and ordered the defendant to the ground. The defendant ignored the commands and continued running and was assisted to the ground by the officer. The defendant stated he ran due to being scared. The defendant evaded approximately 0.4 miles.
What was he doing wrong?
So there was a report of a possible firearm on campus, and the caller provided the name, and he was attempting to investigate that, and he was just trying to detain him to
They
investigate.
give the description of him.
They just gave the name, and then they
A name
ran
of
that
what?
through arms, and they found a picture of that person.
So the caller gave the name of Mr. Newman.
Yes, Judge. Gave Mr. Newman's name. The officer ran that name and found a picture, and then observed him leaving the library and attempted to detain him.
Yes.
And then he ran.
There was also a current trespass notice for the defendant as well.
Yes, Judge.
From TSU.
From the arms or TSU.
Yes, Judge. They found for TSU through arms.
Mr. Newman, I'm going to find that there's probable cause to go forward with your case. Let's do this. I'm going to appoint you a lawyer today because there's several things that we need to look at. So do you mind reaching out to the MAC for Mr. Newman? Mr. Newman, assuming we go forward with the case, you're not to be in possession of any weapons. Do you understand? I'm making that a condition of your bond.
Yes, sir.
If I find that you have any weapons, I'm going to revoke your bond. I'm going to put you in jail.
Yes, sir.
Just all I want is my community to be safe. I'm not asking for much. You understand? Okay. I'm going to have you sign a reset with Victoria, then we'll have you take a seat in the jury box, sir. Okay? So you're charged with driving while intoxicated. You are facing up to 6 months in jail and or a $2,000 fine. You guys have worked out an agreement where they're offering you 3 days in jail with credit for the 2 days that you've done. You need to understand, sir, that this charge will go on your record. It's going to be there for the rest of your life. When you plead guilty, you give up the right to appeal, meaning that you can never change this. Do you understand?
Yes, yes.
You are giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. Do you understand these rights that you're giving up?
Yes.
You also need to understand that there are no more proverbial slaps on the wrist. From now on, you are facing a minimum of 30 days in jail for any new cases that you pick up in here. And if you're not in this country with permission, you do anything short of more than 6 hours, you will get an ICE detainer. So if I were you, I would never, even if you've had a sip of alcohol, get into a car and drive. Do you understand?
Yes, I
How do you plead
understand.
to the offense of driving while intoxicated? Guilty or not guilty?
Guilty.
I'm going to find you guilty. I will sentence you to 3 days in jail, give you credit for the 2. I'm going to suspend your ability to drive for 90 days. Do not drive, otherwise you're going to be right back over here, sir.
Counsel, what happens?
What does your client do for a living, sir? What does your client do for a living?
He does, he's carpentry work, there's labor work, the framing, that kind of thing. Home framing.
I'm asking this because there is a DPS surcharge that they usually tack on for around $3,000. I will waive this fee for you now, but I'm telling you on a DWI second, it's around a $6,000 surcharge on a DWI second. So get a clue. Do you understand?
Yeah.
You're allowed to make a mistake, but when you continue to make mistakes with you endanger other people's lives, there are serious consequences. Good luck, sir. All right, win. All right,
One of the things, there's a portable device, Judge, that you've been.
we'll take it off.
Thank you.
Okay, all right. Please, clerk. Yeah. It looks like you are charged with 2 cases. You are charged with criminal trespass. You're also charged with criminal mischief. On both of those, you're facing up to 6 months in jail and or a $2,000 fine. You've worked out an agreement. They're offering you 48 days in jail with credit for the 16 that you've done on the criminal trespass. They're dismissing the other case.
Yes, Your Honor. Time served on the criminal trespass and dismissing criminal mischief.
Is this how you understand it, sir?
Yes.
You need to understand also that this charge will go on your record. You're now facing a minimum of 30 days in jail for any new cases that you pick up. You give up a lot of rights by entering this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. Like I said, you give up the right to appeal. So once you plead guilty, it stays on your record. Is this what you want to do?
So,
How do you plead to the offense, sir? Guilty.
please.
All right, I'm going to find you guilty. I'll follow the agreement. Good luck to you, sir.
What about the enhancement?
Abandoned.
Yeah.
Or wait a second. Is it listed as?
It's listed as.
Okay, hold on.
True.
Hold on.
Yes.
He's got to. Is it true or, come up, Michelle Z. Is it true or untrue that you had a prior terroristic threat, sir?
I'm on my medication, so I missed my medication. I have trouble getting my medication. I was just,
Did you have a prior terroristic threat in the past? It looks like from August of this past year with us.
I don't remember any terroristic threat towards you. You guys or?
No.
Just in general.
You had a case in this court that you took 57 days time on, and that was August 20th of 2024. Do you remember taking that plea bargain?
I believe I was in the court before, but,
That's all we need to know. That's it. Okay, all right. Thank you. I don't know if have we found probable cause on this first case? Or I mean, on the new case? Let me express my extreme disappointment, Mr. Guevara Ortiz. You now stand charged with yet another DWI. On this one, you're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir.
Yes, Judge. On January 19th, 2025, at 11:43 p.m., the officer was dispatched due to a concerned citizen following a possible intoxicated driver. The call was near Northborough in Houston County, Harris County, Texas. The officer arrived at a public place and observed the defendant, the driver, and sole occupant of the vehicle. And the witness stated the defendant was observed to have severe damage to the front passenger side, and he struggled to stay in its lane several times. The witness had eyes on the defendant until the officer arrived, and the officer made contact with the defendant who advised that he had 3 Coronas and was coming from a gas station where he purchased the beers while driving home.
So drinking while,
No, Your Honor, there's no indication of that. He just purchased while driving home. And the officer observed glossy eyes, delayed responses, and a strong odor of an alcoholic beverage. The officer conducted standard field sobriety tests.
When Judge Fleischer revokes a bond, it's never impulsive, it's earned. A second DWI? That's a breaking point. You can almost hear the disappointment behind his words. This isn't anger, it's a message. Some lessons come the hard way.
HGN 6 out of 6. The defendant refused the walk and turn and one leg stand due to the cold temperatures. The defendant was read the DIC and consented to breath. The results were .189 and .177.
Mr. Guevara Ortiz, I'm going to find that there's enough probable cause to go forward with your case, and I am now going to revoke your bond on your first case, and I'm going to set it at 10,001. You now also have an immigration detainer, so you'll be stuck in there, I guess, until, I need to know, counsel, if you guys are planning on trying to get him an immigration bond or not.
Your Honor, we don't represent him on the immigration case, but it's my understanding from Mr. Breston that there's an effort to address that.
Okay. You're signing on for Mr. Breston there, right?
Yeah, I work for him. Yes, sir.
Got it. All right. Mr. Guevara Ortiz, I'm now ordering you to have an ankle monitor on your ankle, and I'm giving you a curfew of 7 p.m. to 7 a.m. I'm going to put a scram ankle monitor on you so I know that you're not consuming alcohol. On your other ankle, you will get a GPS monitor. I don't know if you're getting out of custody, but if you do get out of custody, these will be your bond conditions. You will have on one ankle, like I said, a scram monitor, so I know that you're not consuming alcohol. On your other, you will get a GPS monitor, so I know that you're abiding by curfew. Do you understand?
Yes.
Okay, so I guess we'll set you out for 30 days. Just keep us in the loop. If you're able to get an immigration bond, you must be here the next business day. If you fail to do so, I'm going to revoke both of your bonds and set them extremely high. Do you understand?
Yes.
Okay, all right.
Thank you, Your Honor.
Thank you, sir. Okay, so tell me what's going on.
Dave's asking for extension.
So this one for Sims, we're asking for an extension from Mississippi for a probation violation for malicious mischief. Obviously, due to Winter Storm Enzo, they're requesting extension because the airports were literally closed.
Get ready, we're gonna get so many of these, you know?
Oh.
Let's get ready.
Yeah, they're coming.
And so this one, they're requesting out to the 27th. The 28th, they'll pick up on the 27th, but because even with when they were originally supposed to come on the 21st, it wrapped around the weekend. That's why we're entering the pre-signed waiver. Ricardo is opposed, which is why I'm entering it.
Okay, I mean, I have to, circumstances beyond, act of God, right? As they say.
Of course, I gotta be opposed. I gotta fight for my client. His expectation was to get out at a certain day, through no fault of his own. He's gotta be here an extra 7 days, looks like. He doesn't control the weather. Nobody does.
Is it 7?
It's because the original pickup date was the 21st. Well, so the 21st, and then the court reset date would be the 28th. They're looking to pick them up on the 27th.
Just get a little bit less than a week. Understand that there is an act of God, right? It just completely close everything. You get just one kernel of snow, the entire city shuts down. So I'm going to grant them an extension. You're not going to get another one.
I have to ask Judge.
So understand, Mr. Kim, that I don't.
They had like 13 days before the snow. That's what I'm saying. Why didn't they come in?
Well, I can't answer that. I mean, that's something.
Oh, yeah.
Judge, I would ask, would you consider giving him a bond so he could go turn himself in and not have to wait 7 days? That's what I was.
For the pre-signed
It's
waiver.
a pre-signed waiver. I
Pre-signed
can't
waiver,
get
he's not allowed.
Understood.
Yeah, I mean, you got to understand, when you get on probation or when you get on parole in another state, you sign conditions. One of those conditions is that if you ever take off and you become a fugitive, you waive extradition. It's a pre-signed waiver. You have already waived by virtue of signing. You need to read every single thing that when you sign it, all the little print, because even if I wanted to give you a bond, I can't, because you have already waived by signing that document.
If for some reason they don't make it by this deadline, will he be getting out?
That's a great question. Mr. Kim?
Unfortunately, with the full, I gotta look at the original waiver date, so it's 5th, so statutorily, they have until February 4th, 2025. So strictly speaking, for the pre-signed waiver, he's not allowed to, but this is one where they've already confirmed they're coming on the 27th. So I think it will be a distinction without a difference because they've already scheduled for him to come on the 27th, unless we get another once in a lifetime storm.
So we're gonna give them until the 4th is what I'm hearing?
Well, the recess is gonna be 28th.
28th.
That's not one.
They already indicated they're coming on the 27th.
I mean, act of God.
I don't see anything happening between now and then. Otherwise, the news would be just going nuts, you know?
Understood. All right,
Yeah.
well,
I mean, should something happen, we'll cross that bridge when we get there.
we're back up here.
They've said that they're going to come get you absolutely on the 27th. I don't know what time, but on that
I'll
day.
confirm with them that we approached and then submit the order and triple check today that that is still the confirmed date, because obviously we've had ones in the past where we confirmed too late and they had to move it. So I'm going to triple check today.
And he'll let you know.
I'll talk to them.
Okay.
Thank you, Josh.
We'll talk some more with you.
Sir, you were charged with driving while intoxicated. You are facing up to 6 months in jail and or a $2,000 fine. You have worked out an agreement where they're offering you 3 days in jail with credit for the 2 days that you've done. You need to understand that this charge will go on your record. It's going to be there for the rest of your life. From now on, you are facing a minimum of 30 days in jail. No more proverbial slaps on the wrist. Do you understand?
Yes.
If you get pulled over, first thing an officer does is they look up your criminal history. If they see prior DWIs and they come up to you and say, smell alcohol, it's probably not going to go well. So from now forth, I would never, even if you had a sip of alcohol, get into a car. You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you plead guilty, you can never take this off. Do you understand? This is what you want to do.
Yes, sir? Yes.
How do you plead to the offense of driving while intoxicated? Guilty or not guilty?
Guilty.
I will find you guilty. I want to send you to the agreement. Let me make one more thing clear, Mr. Espinoza. There is a $3,000 surcharge on this type of case. You pick up a DWI second, it's a $6,000 surcharge on your case that you can probably end up paying. I will waive it now, but understand, if you continue to put other people's lives in danger, it's not going to go well for you.
Muy bien.
Good luck, sir.
Buena suerte, señor.
Thank you.
Can we approach on something? I'd like you to hear probable cause and something.
Absolutely.
You have it pulled up?
Oh, yes, sir.
Okay.
So it's for Klaba. Okay. On January 15th at approximately 6 p.m., officers initiated a reverse prostitution investigation. Undercover officers saw a defendant parked near where she was standing. Defendant rolled down his driver's side window. Officers approached the defendant and had a conversation sexual in nature. Defendant agreed to engage in sexual intercourse with the officer in exchange for $100. Defendant and officer arranged to meet at a motel. Defendant started driving in the direction of the motel. Defendant was then stopped and identified by marked units. During this, officers located a loaded firearm behind the front passenger seat. During the search incident, sorry.
So it would have been yeah. My argument is that the possession of the gun was not while he was engaged in this alleged criminal activity.
And we would understand where he's coming from, Your Honor. However, he did have the loaded firearm behind the front passenger seat, and this was a search incident to arrest. So that's where we would be at.
We have the unusual circumstance here of my client is an aircraft mechanic. He works over at IAH. As a result of the gun case, not the solicitation case, the gun case, he lost his job. He can get it back because he's a member of the union. But the gun case is the only problem because he was charged with a gun. He lost his job. Now, I assume we're going to be able to work out the solicitation case with the
I
stand.
mean, I'm sure would probably work out in conjunction as well, you know? I mean, it's,
So, but in the meantime, he can't work. So,
let me read the statute. Hold on.
That one will have to finish ours. Oh, what if he's one of the seats?
I tried to replace my plumbing, but I forgot to shut off the water. It's been all you gotta do is glue stuff.
So I'm looking at 46.02. Unlawful carrying of a weapon. A person commits an offense if the person, one, intentionally, knowingly, or recklessly carries on or about his or her person a handgun at the time of the offense. So is this at the time of the offense? Right? I guess there lies the question.
He was proceeding to the motel where the incident, that they agreed to would occur, so during the process.
So, because, I mean, the offense is committed when? When the actually agreement took place.
requires the way the charge reads, it requires, the offense is complete at the time that an agreement is
reached.
made. So
The agreement is made at the time, allegedly, when they're stopped. They had the wherewithal, if they wanted to, arrest him at that time, where subject to arrest at that time, they could have made the charge, so to speak, right? But they decided to wait.
Well, Your Honor, if I may, the statute reads they had honor about his person while committing criminal activity, and the firearm was in the vehicle while the offer was being made. It was just on the way to the hotel or the motel is when they stopped him and search incident to arrest for that solicitation. That's when they found the firearm. But the firearm was on or about the defendant's person while he was engaged in the offer for the solicitation.
And also, if I may, Judge, I would also say it would make sense for safety procedures for them to make the arrest while he was on the way to the motel so that they could have followed him and it wasn't just that undercover officer there at the scene and making the arrest.
No, I don't know, because they could have arrested him at the time, right on the spot. I don't know why they would try to bolster the case, I guess, by saying that there's more evidence of guilt by actually going to the motel. I mean, theoretically, they could have arrested at the time that the agreement is made, right? It's a contract.
Judge, I think we would just stick to the way the statute is worded is while engaged and the firearm was there. And they could have arrested him earlier, but as Mackenzie knows, they do that routinely for safety purposes as well as perhaps as you mentioned, they could have done it for further evidence as well, further investigation.
Prostitution cases I've seen is they arrest right on the spot, right then and there. They don't wait. I mean, the offense occurs right then and there.
And the offense did occur and while the defendant was in the vehicle, that's when the offense occurred. He was in the vehicle when they made that agreement and the firearm was in the vehicle. They found it right after they followed him to the motel. It was in the same transaction.
the offense was complete.
I agree with you. I'll find no probable cause. Okay.